on behalf of the governors, the management and indeed the entire college community to welcome you all here to this prestigious event. We are delighted that St Colum's was able to host it, and we hope very much you enjoy the afternoon. A special word of welcome obviously to our guest speaker, Sir Declan. He needs no introduction, I'm sure, to most of you. Certainly not to his mum, who's back there. Annie, delighted to see you here. I did try, at the weekend to wheedle a few sentences out of her. I thought maybe I could wash some private linen in public. Dirty linen at that too. But she told me he actually had her sworn to secrecy. So, not a word. Could I also thank the committee, particularly of the Past Pupils Union, for setting up today's event. Certainly it's been in the offing for some time. I think the seat was sold by Judge Hilary Keegan, who's here, glad to see you, Hilary, and brought to fruition by Mr. Paul Hassan. Ably assisted, if I might say so, by Dermot Carlin and Joe Stewart. They both do a tremendous amount of work behind the scenes for the Past Pupils, and I'd like to take this public opportunity of acknowledging their input. On top of that, I'd like to thank anyone else involved in the organisation, a number of people in the school, and I'd like to thank the PSNI for all the work they've done in liaising with us over the past few days, and for the security that we've been able to put on today. As I say, there's no need to introduce Declan, but I can think of no man better qualified or more able to speak to us today on the subject of justice in a devolved environment. I looked obviously on Wikipedia and one or two other sites, and the string of achievements attached to his name is frightening almost. I'm going to read just a few of them out to you. Called to the bar in 1976, Queen's Counsel in 93, Senior Crown Counsel for Northern Ireland from 2002 to 2004, Judge in Residence at the School of Law at Queen's University, Judge of the High Court 2004, Chairman of the Law Reform Advisory Committee for Northern Ireland 2004, and in 2007 appointed to the Family Division of the Court, and in 2008 moved to hearing cases for judicial review. On June the 18th, 2009, it was then announced that Sir Declan would be the next Lord Chief Justice. Subsequently, he was sworn in as member of Her Majesty's Most Honourable Privy Council on the 3rd of July 2009. I think probably when I read something, a list such as that out as quickly, there's the possibility at least that we fail to appreciate fully the significance of those achievements. And I think we can sometimes forget the incredible intellectual capability and the capacity for sheer hard work, as well as the depth of wisdom that resides in this gentleman today. I have no doubt at all that today we're in the company of a particularly talented individual. You'll have noted by now, of course, that I left out probably the supreme accolade, and that was the accolade last year bestowed upon him by St Colum's College when he was nominated for the 2010 Alumnus Illustrissimus Award, an award that he bears both very humbly and at the same time, I'm told, he is particularly proud of. I wouldn't want to canonise the gentleman just yet though. So I would also point out to you that on the evening of the award being presented, I had the privilege and indeed the enjoyment of being beside the gentleman for the evening of the dinner. And I can assure you that he's not perfect. In the course of which I suddenly discovered that he has quite a mischievous sense of humour at times and is partial to telling, I didn't tell them, a naughty story. And those of you who know me will know how easily shocked I am. You know me too well, some of you. And I was shocked in numerous instances that night. However, as a dinner companion, I found him both stimulating and challenging. It intrigued me, and indeed I shouldn't have been intrigued and I should not have been shocked at the depth and breadth of the man's knowledge of matters educational. I also found that in the course of the evening, I thought at one stage I was being cross-examined. He was asking so many questions about education. The thirst for knowledge is still clearly there and as yet unquenched. I think by the time the evening had finished, I was actually asking myself which of us was the school principal. In the short time since Sir Declan's appointment as Lord Chief Justice, I think he's made one of his priorities quite clear, and that is that there would be a much greater understanding of the law, the legal system, and how judges work, and how the whole judicial system works, and that that understanding would be accessible and readily disseminated to the man in the street. And I think he is to be lauded for that. Towards this end, he has set up a Criminal Courts Judicial Committee to look at the causes of delays in the judicial system. There's also been a review body established to look at sentencing. Alternative dispute resolution and mediation methods are also being investigated. Public opinion on all of these matters is frequently canvassed and clearly valued, and I think that again is to be lauded. Clearly today I think we can say that we have with us a Lord Chief Justice who's interested not only in dispensing justice, but also in reviewing, refining, reforming and improving many areas of our legal system in a highly creative manner. It's therefore with the utmost confidence and considerable expectation that I now place you in the very capable hands of the Lord Chief Justice of Northern Ireland, the Right Honourable Sir Declan Moore.
Thank you very much for that extremely generous introduction. I'm glad that you set the expectation level just as high as you did. I'm entirely sure that I shall achieve it. I think it was Adelaide Stevenson who said that when people say nice things about you, you are allowed to enjoy them, but you shouldn't inhale. It's a great honour to give this lecture. This lecture flows from a series which started to celebrate the 125th anniversary of the College on the subject of culture, change and challenge, and was designed to provide an opportunity for reflection, discussion and new thinking around key areas in literature, politics, science and education. And there are a raft of extremely distinguished people who have given this lecture before me, including one of my former colleagues, Liam McCullum. However, it occurs to me that the invitation to a senior judge to give a lecture on a legal topic of his or her choice isn't exactly an auspicious indication of an enjoyable night out. Having accepted the invitation, I'm not necessarily, I'm afraid, going to provide something that is going to be humorous, but I hope that it will be something that is informative. I also want to make it clear that this is the first of 3 lectures that I will be giving in different venues over the next 2 weeks, which will touch upon the subject of judicial independence, and for reasons that I hope will become clear in the course of the lecture, I hope that you will appreciate not just that this is important to me, but that it is also important to you and to other members of our community. The lull between the end of the Executive's first full term and the rapid crossfire of the pending election campaign presents an opportunity to reflect on the role of the judiciary in our new and developing Northern Ireland constitutional structures. This has been a time of considerable change. We now have almost reached the end of the first year of the devolution of justice. That has brought us a new Minister of Justice, a new Attorney General, and a new Justice Committee, the Vice Chairman of which is one of our local MLAs. My own appointment and that of the Chief Constable are relatively recent, and we will soon have a newly appointed DPP. So it might be tempting, therefore, to view this period as a time for change. And I fully support the view that this is a time for us to take advantage of the opportunities available to us to develop our justice system. But I consider that if we are to do so successfully, we have to build upwards from a bedrock of principle and fundamental values that provides us with a secure base. The rule of law is one of the fundamentals upon which our democracy is based. It has a distinguished pedigree. In the common law world, it can be traced back to Magna Carta in 1215. It featured strongly in the Bill of Rights in 1689 and the Act of Settlement in 1701. It is to be found in Article 6 of the Constitution of the United States of America and in the French Declaration of the Rights of Man and the Citizen in 1789. And aspects of the rule of law form part of the Universal Declaration of Human Rights in 1948 and the Constitutional Reform Act in this jurisdiction in 2005 recognises the rule of law as a constitutional principle in this jurisdiction. The content of the rule of law shows its importance to every one of us as citizens. There are really three features. First, the individual is protected from interference by the state otherwise than in accordance with law. Second, the same law applies to everyone regardless of their position in society. And third, the content of laws must respect fundamental principles of transparency and fairness. The rule of law is not, therefore, empty rhetoric. It is fundamental to the exercise of the rights and freedoms of each of us. In his book entitled The Rule of Law, published in 2009, shortly before his death, Lord Bingham, the foremost judge of his generation, who incidentally was born and bred in Belfast, described the alternative. He said, "The hallmarks of a regime which flouts the rule of law are alas all too familiar. The midnight knock on the door, the sudden disappearance, the show trial, the subjection of prisoners to genetic experiment, the confession extracted by torture, the gulag in the concentration camp, the gas chamber, the practice of genocide or ethnic cleansing, the waging of aggressive war. The list is endless." The sobering thought for all of us is that some of these things are entirely familiar in connection with the recent activities of some Western democratic states. That alone should remind us of the importance of eternal vigilance in this field. The primary responsibility of the judiciary is to make their contribution towards upholding the rule of law. The primary function of the judiciary in exercising this responsibility is the fair and impartial resolution of disputes between individuals and between individuals and the state in accordance with law. No other organ of the state carries out this function. It is evident, therefore, that in order to carry out the function, the independence of each judge is of critical importance. It can properly be described as the precondition for the ability to carry out this responsibility. It is also important to note that the judiciary are required to make their decisions in accordance with law. The rule of law is not the rule of judges. Judges, like everybody else, are subject to the laws as enacted by the legislature. As I have indicated, the rule of law is not there to create some sort of privileged position for judges, but is necessary for each of us in a democratic society. There has been a tendency to characterise the role of the judiciary in the resolution of disputes between the individual and the state as being the protection of the individual against the abuse of power by the state. It is not a characterisation which I either approve or recognise. There will, of course, be occasions where the rights of the individual must prevail in accordance with law, but in many cases, the obligation which the law imposes upon the courts is to strike a balance between the rights and freedoms of the individual and the protection of the rights and freedoms of the community. Where they arise, these are often difficult balances to strike, but the duty of the judiciary is to ensure that the balance is struck in accordance with law, without fear or favour, affection or ill will. Every party before the court is entitled to a fair and impartial resolution of the dispute. As Sir Sidney Kentry said in a recent lecture I attended, the government isn't always wrong. Having established, therefore, that an independent judiciary is a necessary precondition for a democratic society that is governed by the rule of law, I want to acknowledge the extent to which this is recognised within our broad constitutional structures. There are statutory obligations on ministers in the Justice Act 2002 to guarantee judicial independence, and similar provisions in the Constitutional Reform Act 2005, applying in particular to the Lord Chancellor. The importance of judicial independence was also expressly recognised in the Hillsborough Agreement, which preceded the devolution of justice. One can see, therefore, that our constitutional structures have expressly recognised the critical role which an independent judiciary has to play in securing our democracy. None of that tells us, of course, what the constituent elements of judicial independence are, and it is to that that I now turn. Some of the sources for this are of long standing. The Act of Succession in 1701 provided for security of tenure and protection against reduction in remuneration. Similar provisions are found in Article 3 of the Constitution of the United States of America and are replicated in many written constitutions in the common law world and beyond, one example being the Republic of Ireland. It is, however, to the most recent international standard that we must turn in order to determine what judicial independence requires in modern democracies. The Bangalore Principles of Judicial Conduct, adopted in 2002, were developed under the auspices of the United Nations by an international group of senior judges and have been used to develop protection for judicial independence throughout the world. They set out the core values of the judiciary and identified independence as one of them. And in January 2010, the Judicial Integrity Group at its meeting in Lusaka, Zambia, adopted measures for the effective implementation of the Bangalore Principles, and these include the measures to be taken by the state for securing judicial independence. I intend briefly to refer to those measures which need to be put in place, but I want to emphasise at the start that although each of these measures in itself is important, this is not a catalogue from which one can pick and choose. All of these measures need to be addressed if, as a justice system, we are to achieve the appropriate international standard for judicial independence and thereby adequately protect the rule of law within our democracy. The first measure is the responsibility of the state to provide constitutional guarantees for independence. This has achieved statutory force in our jurisdiction, as I've said, through the Justice Act and the Constitutional Reform Act. The measure also requires that judges are able to act without pressure, threat, or interference, direct or indirect, from any quarter, but particularly from those exercising executive or legislative power. It would be churlish of me not to acknowledge the respect for this aspect of judicial independence which the Minister of Justice in this jurisdiction has shown in his year in office, and the assistance which the Attorney General has provided in disseminating information on this issue. Unhappily, however, there are recent examples of conduct by senior cabinet ministers in the United Kingdom which might lead one to question their commitment to the upholding of judicial independence. The measures also deal with the importance of judicial appointments, tenure of judges, and judicial remuneration. We now have an independent Judicial Appointments Commission in Northern Ireland, which accords with the required international standard. Tenure of full-time judges is secured to a fixed retirement age, and although there is some legislative protection for judicial remuneration, it is not clear whether those provisions secure the right adopted in Lusaka that the salaries, conditions of service and pensions of judges should be guaranteed by law and should not be altered to their disadvantage after appointment. All of these features are designed to ensure that neither an individual judge nor an independent judiciary generally should be at risk of financial disadvantage from a disappointed legislature or executive. Although the tenure of judges must be protected in order to secure independence, there is now in place a disciplinary system to ensure that high standards of probity and integrity expected of judges are maintained and that appropriate action is taken if such standards are breached. In respect of serious breaches, an independent authority is now in a position to recommend judicial removal, which again corresponds to the highest international standards. The last measure to which I wish to refer is that dealing with the budget of the judiciary. The Lusaka measures provide the budget of the judiciary should be established in collaboration with the executive and should be administered by the judiciary itself or by a body independent of the executive and legislature which acts in consultation with the judiciary. This measure has been implemented in Scotland and the Republic of Ireland by establishing non-ministerial departments with a preponderance of judges on the oversight boards. I have already indicated to the Minister that some such model appears appropriate for Northern Ireland. Primary legislation would be required, and it was not therefore possible to deliver this during the term of the last executive. I wish to make it clear, however, that strategic control of the budget for the administration of judicial work is a fundamental aspect of judicial independence, which I would expect to see delivered in the forthcoming Assembly. I've spent some time focusing on the obligations of the state to secure the highest international standards of judicial independence. As is clear from what I have said, there has been considerable progress in this area, and although we have a long way to go, I am confident that those with responsibility for those areas recognise the need to demonstrate that our justice system can meet these standards. It is right to say, however, that the need to secure judicial independence lies not just upon the state. Internally, the judiciary also have to promote and secure independence. Every judge is an independent judge. No judge can be told how to deal with a case or what conclusion he or she should come to. The independence of the judiciary includes the personal independence of each and every judge to reach their own conclusion according to law. I want to talk briefly about judicial accountability. I confess that I have considerable reservations about the notion of judicial accountability. Everyone agrees that judges ought not to be accountable for their decision-making to the legislature or the executive. I entirely accept that the judiciary have an obligation to take all reasonable steps to secure public confidence in the administration of justice. But that does not make judges accountable to anyone. I prefer to characterise those matters which are often identified as aspects of judicial accountability as aspects of fulfilling that obligation of securing public confidence, and therefore aspects of responsibility. Judges, like many others, have responsibilities, but sometimes, of course, it can be difficult to secure public confidence because the right decision is not necessarily the popular decision. In fulfilment of those responsibilities, judges are therefore expected to give decisions which explain the reasoning for the outcome. If any party is dissatisfied with the outcome, they frequently have a right of appeal. If there is any aspect of a judge's work that can properly be described as judicial accountability, this is it. If the decision was given in writing, it ought generally to be made available quickly, usually on the internet. Where decisions are likely to give rise to public interest, there is now a fairly widespread practice of ensuring that summaries of the decision are made available for the benefit of the parties and the press. Where there is media interest in the decision, we have a judicial communications officer whose responsibility it is to liaise with the media and deal with their queries. Senior judiciary also regularly give public lectures which explain the work the judges do, and I made a lengthy statement at the beginning of the legal year setting out the judiciary's objectives for the coming year, which I would intend to repeat annually. And there were a lot of people who attended that last year, but since it went on for so long, it'll be interesting to see whether any of them turn up again next year. Something like this lecture, I suspect. In this context, I also want to mention the relationship of the judiciary with the media. A free and independent media is an essential element of every democratic state, and the existence of an independent judiciary to administer the rule of law is essential to secure the media's right to free speech. The media are plainly entitled to criticise any judicial decision with which they do not agree, and where appropriate, to campaign for changes in the law if deemed necessary. In doing all of this, the media have, of course, a responsibility to present an accurate and comprehensive account of the material facts. But none of this can ever render the judiciary accountable to the media. I have spent some time on issues connected to judicial independence because I have been aware from my many informal discussions with members of the public that there is often a lack of understanding of why judges need to be independent, what it means to say that a judge or the judiciary are independent, and why judges are not and should not be accountable outside the system of appeals for their decisions. Although the responsibility for explaining this to the public lies with others as well as the judiciary, I accept that we must also use occasions such as this to explain our role in the constitutional firmament. It should also be apparent that the justice system has a host of participants, all of whom have differing roles and responsibilities. Devolution of political control of justice has put great power in the hands of our elected representatives. In particular, the legislature can now make law in virtually any sphere of the justice system. The minister and executive can focus on priorities and provide budgetary support to reinforce those priorities. There are, however, aspects of the justice system which lie outside the political control of the Assembly and Executive, and one of those is judicial decision-making. The omission is deliberate. It is intended to reflect the checks and balances which are appropriate in a democratic society. It ought not to be a source of concern. On the contrary, it should be recognised as a necessary and desirable feature of a justice system aspiring to achieve the highest standards. Finally, before I leave this aspect, I want to acknowledge the enormous responsibility which the independence of the judiciary places on individual judges. The Lusaka implementation measures make it clear that we must promote the principles of judicial conduct identified in Bangalore, which we have done through a code of ethics. We have established a complaints system for matters outside judicial decision-making. We have actively pursued with the professions the introduction of pro bono schemes to promote access to justice, and have refined our approaches to case management in order to ensure the just, orderly and expeditious conduct of court proceedings. Through the provision of summary judgments and promulgation of decisions on the internet, we endeavour to keep the media and the public informed about the business of the courts. A very substantial part of our work involves the continuous training of judges to ensure that we have an up-to-date professional judiciary and to ensure consistency in areas such as sentencing. We recognise that we must continue to pursue the highest standards in order to secure the confidence of the public in our work. At an earlier stage in this paper, I indicated that I fully supported the involvement of the judiciary in initiatives which are likely to have a beneficial effect on the justice system as a whole. It is important to emphasise that judicial independence does not mean judicial isolation. Judges have an important role to play in helping to improve our justice system, and we should actively engage with other elements of the justice system and the public to achieve that purpose. We have been taking active steps to take advantage of the new opportunities. As is apparent from the earlier discussion, because the justice system has a number of participants, in order to establish appropriate checks and balances, it is important for all of us to ensure that the checks and balances do not operate as barriers to worthwhile progress. One of the issues which has been a source of particular concern for the Minister is avoidable delay in the criminal justice system. We have recently established a series of meetings with the PSNI and the PPS in which we have exchanged ideas about how we might better secure the attendance of witnesses and manage cases to earlier trial dates. In doing so, we all drew upon some of the work that have been conducted by the Criminal Justice Inspectorate in their report on avoidable delay. The reason that I mention this example is to highlight the ways in which the different parts of the criminal justice system can work together. Here was a ministerial initiative on